the letter, excuse me, Eric, the letter that was submitted tonight, or, I'm sorry, Jamie, the letter that you submitted tonight directly refers to this section, is that correct?
That is correct.
Vice?
Certainly, I don't have nearly the experience in federal court that Mr. Goldsmith, I believe, has, although I don't know. But ordinarily, for the granting of an injunction, there has to be some proof that there's actual damages and it's going to be a problem. I suspect it may end up to be a battle of experts, and the court rely on the experts that the wind energy facilities bring in, and as long as we stay out of it, well, we're not getting dragged into that. The fight will just be between their experts saying there's a problem or not. Courts tend not to want to issue preliminary injunctions if it is overly speculative. If they may very well say, well, you're going to have to prove there's a problem before we'll grant the injunction. Now, in this case, you're going to have a, theoretically construction of the wind turbines, and then being forced to shut them down if they create the interference. So the judge may be inclined to grant them temporarily. Not knowing which federal judge you're going to end up with, it's almost impossible to predict which way he or she is going to go. But ordinarily, they tend not to want to grant injunctions if they don't have to. They're reluctant to do it to grant permanent or temporary injunctions that would probably require a full-blown hearing. And without giving legal advice to either side, it would seem that if the wind energy facility lost it and the injunction was installed, they would probably drop back and try to come up with a new program. And so whether there would be a permanent prohibition of wind turbines is not necessarily true. I mean, if they say, okay, they're too tall, and then if there's a remedial provision that the LMBs says, well, if you did this and that, they could very well say, fine, we'll do it. And then to comply. But it's going to be quite, I think it'll be awfully speculative, and to know which judge you're going to have and how he or she is going to view it is almost impossible to predict an outcome.
Dr. Leonard, did the Planning Commission consider the alternative wording?
Yes. Some of it, this is a personal opinion, I thought that the board was going to go with an alternative language.
But
they didn't.
But they did.
Some of it was, do we have any jurisdiction outside the township? Ideas. In other words, do we have any say in what happens in Raga and other areas? So that was one of the things the board felt, no, we don't have any say. The only thing, the only concern about.
Okay. Any further questions, board?
I would like to, not really ready for a motion, but I would like to talk about alternative B. I was on the Planning Commission board, and I think that I moved, when we reviewed this, line 21, I may have moved for that wording, and since that time, do you remember, Jim, if I did or not? But that doesn't really matter.
It failed, I'm pretty sure it failed.
Apparently did, because he's not here.
If B possibly, does anyone else on the board have any feelings about that?
Are you suggesting perhaps that we use the current language in 21 plus B?
Well, will you need to, or you could replace I don't know if you can combine them, Jim, or maybe the board feels it's we're good where we're at.
Just a note that if I move or support, or if any of us move or support a motion, doesn't necessarily mean we're for it. Okay? I do believe that we owe it to our planning commission to move forward with consideration of their original wording. Therefore, I move that we adopt section 21 as worded.
Support.
Motion, I support Terry, that we adopt section 21 as printed. Discussion. Seeing none, all in favor say aye.
Aye.
Opposed?
Aye.
Motion fails. What's your pleasure? Is there a motion to adopt the alternative wordage for 21 and B?
These
So
would be,
moved.
I'm sorry, you beat you just a little bit. What was your question?
I was gonna say it's either A or B, it's not gonna be both, correct?
No, I believe A and B, is that correct?
A is for, in the alternative wordage, 21A is for.
Correct, and then B is an addition.
Yeah, 21A is for radio and those things, 21B is for TV.
Okay, all right.
Sorry.
Does that clarify your question?
Yep.
Steve?
I move we adopt the alternative wordage 21A and B.
Is there support?
I'll support.
Motion Pappenhagen, support Meyer. The alternative wordage for section 21 A and B be adopted. Discussion. Seeing none, all in favor say aye.
Aye.
Opposed?
Aye.
Chair calls for division. All in favor, raise your right hand, please. Opposed? Motion carries. Okay, on to 5, which is now 5-1. Is that correct? It's 501. Application fee. I move that 5-1, item 1, application B be approved as printed.
Support.
Motion Isaac, support Ball, that 5.1, item 1, application fee be approved as printed. Discussion? Seeing none, all in favor say aye.
Aye.
Opposed? Motion carries. Site plan fee, 5-1, item 2. I move that 5-1, item 2 be adopted as printed.
Support.
Motion Isley, support Terry. 5-1, item 2 be adopted as printed. Discussion? Seeing none, all in favor say aye.
Aye.
Opposed? Motion carries. Dwelling unit impact fee. So we pulled, one of the suggestions here was that we delete dwelling unit and place in inhabited structure. I've been told it's supposed to be habited. Is that correct?
Inhabitable.
Inhabitable?
It may not be currently inhabited, but it could be inhabited.
Good point. I move that. Okay. Yes. Okay. Yep. I move that section 5.1, item 3, it should be changed to dwelling unit impact fee, but they're going to that we approve item 3 with the striking of dwelling unit, replacing that wordage with habitable structure. In 4 locations. Is there support?
I'll support it.
Motion Isley, support Ball. 5-1, item 3 be approved with the amendments of striking dwelling unit and replacing those words with habitable structure. Is that discussion? Seeing none, all in favor say aye.
Aye.
Opposed? Motion carries. We need to go back to definitions. Page 2, bottom, shows inhabited structure. That would need to be changed to habited. Habitable, thank you.
Jim, may I? In the council in Riga suggested, as much as I like impact fees, that they were not legal to put in an ordinance. I defer to Frank, of course, but that we had those discussions at length, whether or not they were permissible in zoning in the state of Michigan.
Get there. I move that on page 2, under section 2, definitions, inhabited structure, the word inhabited be struck and replaced with habitable.
Support.
Motion Ball, motion Isley, support Ball, that section 2 definitions, inhabited structure, inhabited be struck, and replaced with habitable. Discussion? Seeing none, all in favor say aye.
Aye.
Opposed? Motion carried.